part of this lecture may be used without the express written consent of Rick Ramos or Contra Costa College. Hi, this is Professor Rick Ramos, and we're in the Legal Aspects of Evidence course. We're going to be jumping into Lecture 2, Part 1. And one of the things that I need to let you know is that I need you to check the D2L webpage and look under assignments to see whether or not you have other assignments that are going to be required, including but not limited to a student workbook, which is a fill-in-the-blank workbook that will help you as you're reading the textbook, which is Ray Hill's Criminal Evidence textbook. It should assist you in writing down pertinent data that will help you remember key terms for this course. Now, one of the things you need to remember is that the Legal Aspects of Evidence is the highest flunked test in the state police and law enforcement academies for both probation, parole, and law enforcement and corrections. So it's really important you pay attention in this course, and this course can really help you get that job down the line. So let's jump into today's lecture. What we're going to be talking about is trying to get you to understand two different concepts: direct evidence versus circumstantial evidence. Circumstantial evidence is also called presumptive evidence. And in direct evidence, most crimes that are often proven by direct evidence include robbery, kidnap, rape, domestic violence, and aggravated assault, because in direct evidence, the person actually saw the person do it or experienced the crime, and they can testify directly about it. Some of the crimes that are most often proven by circumstantial evidence are murder, burglary, and identity theft, because there's usually no witnesses. In murders, there's going to be some witnesses, and those people would be able to testify to direct evidence. But in cases where you find a dead body in a field, most of that evidence is circumstantial, and you're going to be using fingerprints and blood and a variety of other types of evidence to prove your case. So let's start off with the definition of direct evidence. And it is evidence which directly proves a fact without inference or presumption, and which in itself, if true, conclusively establishes the fact. Again, evidence which directly proves a fact without inference or presumption, and which in itself is, if true, conclusively establishes a fact. Direct evidence most often involves the testimony of a witness who personally observes or perceives a fact. Examples could be that the witness testified he saw the suspect commit the robbery, or the officer testifies that he saw the suspect run a red light, or a forensic chemist testifies that the suspect had a blood alcohol level of 0.009. So we're really looking for situations where a witness testifies that I saw this, or I did this, or I heard this, or I said this, or I was told this, or I found this, or I recovered this, or I smelled this, or I wrote this, or I collected this. Now, the difference between that's direct now, and circumstantial evidence is that direct evidence is proof. The direct evidence of one witness is sufficient to prove a fact without the necessity of offering other evidence, and that comes from 411 of the Evidence Code. Examples include testimony concerning any particular fact which the jury believed from one witness is sufficient for proof that that fact, upon full review of all testimony upon which the proof that fact depends. So what that means is that all it takes is that one witness's testimony to convince the jury that something happened. That's the translation for that. California jury instructions include the fact that the testimony of a rape victim doesn't need to be corroborated by another witness or other evidence in order to sustain a conviction. That comes from People v. Hollis in 1991. Evidence which can corroborate this testimony is always beneficial. If credibility issues should arise with victim or witness testifying, corroborating evidence may be necessary to maintain the prosecution's burden to prove the criminal guilt beyond reasonable doubt. In other words, in a case like that, in a rape case where the witness is testifying, if there's some doubt as to the credibility of the witness, then you might want to have some corroborating evidence, because basically the trier of fact is the one that's going to make the decision. So the jury in a case like that, or the judge, depending on whether it's a bench trial, is going to have the ultimate decision as to how much truth there is to the statement of the witness. Circumstantial evidence, on the other hand, is evidence which proves a fact through an inference or logical association with another fact, meaning that you look at a set of circumstances and from that you derive a conclusion that may or may not be true. The defendant's fingerprints are recovered at the crime scene. We can infer that the defendant was present even though there is no witness to the crime. That would be one example. With circumstantial evidence or indirect evidence, it's going to be called a couple different things, so know this. Presumptive, because you have to presume something. Circumstantial, because the circumstances lead you to believe something. Or indirect evidence, meaning that no one actually saw it happen, but there's evidence to it. So with circumstantial evidence or indirect evidence, the district attorney or defense attorney first proves that fact A existed, and the trier of fact is then asked to conclude through an inference, which is a deduction of fact that may be logically and reasonably drawn from another fact, that fact B logically follows from that evidence. So I'm hoping that you understand this term inference, or reaching a logical conclusion. And you might want to go to a dictionary and look up the word conclusion. So what's happening is that in circumstantial evidence, for it to apply, there's got to be a medium of facts or things that you're looking at. The characteristics of the circumstantial evidence are, first, the existence and presentation of one or more evidentiary facts, and second, a process of inference by which these facts are so connected with the facts sought as to tend to produce a persuasion of its truth. In other words, because you see something or you hear something or you have a list of facts in front of you, it persuades you to believe a conclusion. So an example would be fact A, and we're going to use this fact A, fact B. So fact A is a medium of facts that you're going to review, and fact B is the logical conclusion, okay? So fact A, during a search warrant service, indicia of occupancy or ownership belonging to the defendant, including canceled checks, utility bills, rent receipts, photographs, keys, etc., were found in the same room as narcotics packaged for sale. The trier of fact may infer or logically conclude that, and this would be fact B, the defendant occupied the bedroom and was in constructive possession of the contraband. Constructive means that they had control of the contraband even though they weren't there at that time. Let's look at another one. So fact A is the defendant was seen running from a burglary scene. A hot pursuit ensued where they foot chase this person down, and upon capture, he physically resists arrest. The trier of fact may infer or logically conclude that, and here's your fact B, the defendant admits by his conduct that he committed the burglary. And this is through a process we call consciousness of guilt. So there's times when people will leave evidence at the scene. There's a little article that I've put into notes and that are in other lectures that talk about where somebody will leave their ID at the scene. I've had that happen on burglary cases or robbery cases, or fingerprints on the countertop. Or in a homicide, the person left their glasses there, and glasses have a smudged fingerprint on them. Other types of circumstantial evidence can include blood typing, or hair samples, or footprints, or fiber evidence. In a homicide with no body found and a lethal quantity of blood at the scene, you could use this to show that a person had to have died. In other words, you only have so many liters of blood in your body, and if there's that amount on the ground, then it's got to be presumed that you're dead. Some other examples could include that evidence that a defendant's fingerprints were found on the premises of a methamphetamine lab and on the containers for precursor chemicals that are used to make methamphetamine, and that he fled the premises when police arrived, were circumstantial evidence supporting a drug trafficking conviction, and this is People v. Duran in 2001. Additional examples could be that a victim is missing, the room shows signs of struggle and blood's found at the scene, there's bullet holes in the wall with blood and hair samples that are removed. that could be used, or constructive possession of a controlled substance established by indicia of occupancy with the dope, and I already talked about that earlier, where the person's ID and everything are found with the narcotics in a certain room. Or that a suspect buys a large insurance policy on her husband before he's found poison. Other examples could be that a CHP officer was dispatched to a dark, desolate intersection in rural Contra Costa, and while en route, the officer saw no other vehicular or pedestrian traffic on the roadway, and upon arrival, the officer observed the defendant, who was the only person at the scene, covered in mud from head to toe. He had a laceration, a cut above his one eye, and his vehicle was partially covered in mud, raised up on it to a hand jack, and one tire had been removed. The defendant had the keys to the car and the tire lugs in his pocket. The defendant showed obvious symptoms of being under the influence of alcohol, failed sobriety test, and was arrested for DUI. The defendant argued that there was insufficient evidence to prove that he had been driving the vehicle. The District Court of Appeals ruled that the defendant's proximity to the vehicle under these circumstances was sufficient circumstantial evidence to support a reasonable inference that he was the driver of the car. This is People v. Scott in 1999. Other examples include during an airport search, 6.5 pounds of cocaine were discovered inside a chessboard set. The defendant claimed he was carrying the item for someone else and had no knowledge of the legal drugs inside. A jury could infer knowledge of the drugs from the following circumstantial evidence: large quantity of drugs, secreted location, nervous behavior and anxiety during the inspection, frequent trips outside the U.S., possession of a similar chess set on a previous trip, and contradictory statements regarding past trips and possession of the item. This was U.S. versus Barbosa in 1990. Next example. Phone calls answered by officers while serving a narcotic search warrant were callers who were asking for the defendant and placing drug orders, saying things like, "May I speak to George? I want a 1/4 gram of stuff and an 8-ball." This was circumstantial evidence sufficient to show that the cocaine seized at the premises was possessed for purposes of sale. And this is People v. Neely in 1991. In the Polygraph case in Sonoma County, the prosecution of Richard Allen Davis, the district attorney presented circumstantial evidence of lewd conduct with a child. A specialty condom similar to that purchased by Davis several days prior to the Polly's abduction was found unrolled near the scene where she was allegedly bound. Polly's body was found with her nightgown pushed up to her chest, and there was fiber evidence on Davis's clothing indicating contact with Polly's clothing. The method of operation of binding Polly in a ritualistic way matched the method of operation of Davis's past crimes, and the psychological profile evidence pointed to Davis's fantasies involving non-consensual sex crimes with women, paraphilia, and from this evidence, the jury concluded there was lewd touching with the intent to molest the victim. And this is a special circumstance that you need for the death penalty, even though the post-mortem examination was inconclusive on the issue of sexual assault. So finding the condom, finding the fiber evidence of her clothing, the way that she was bound, showing that prior MO, and the psychological profile showing that this guy had fantasies of doing these type of crimes led to the special circumstances conviction in that situation. There can also be other examples. First of all, let's talk about presumptions. What the heck is a presumption? When you presume something, what does that mean? Presumptions are an assumption of fact that the law requires to be made from another fact or group of facts. So it is a conclusion that you're going to make based on other facts. Examples of presumptions: things which people possess. If you have guns, knives, explosives on your person, in your control, it's presumed that you own them and have control of them. That's under 637 of the Evidence Code. A person who keeps a rental vehicle for 5 days past its return date is presumed to have embezzled the vehicle. These sort of crimes are considered general intent crimes. Possession crimes are general intent crimes. An unlawful purpose is presumed from a person who knowingly and willingly commits an unlawful act. except in crimes involving specific intent. What that means is that in general intent crimes, no specific state of mind has to be proven for you to be found guilty of that crime. That it's presumed that because you did it, you meant to do it. The next definition will be on the term inferences. An inference is the deduction of fact that may be logically and reasonably drawn from another fact or group of facts found or otherwise established in the action, and this comes from 600 of the Evidence Code. Where a presumption must be followed under law unless you're able to argue against it, the deduction argued in an inference is permissible and may be given credibility by the trier of fact, meaning that if the suspect's ID is left at the scene of the robbery and his fingerprints are left on the counter in a specific place that can be identified through direct evidence, testimony, but the person has on a mask so he can't be identified, that it could be presumed that that's the person. Other examples of inferences include possession of stolen property, which requires the suspect had knowledge the property was stolen. This can be inferred if the suspect is evasive or lies about how they got the property, or is unable to tell you how they got the property. Another example of an inference is that if you find indicia of occupancy, now I want to make sure you understand what indicia of occupancy is. If you look in the book, it's going to give you a definition. It's basically things that would make someone believe, right? You would presume, again, it would be presumptive evidence, that the person is in control of a certain area. So if I rent a house, I'm going to have rent receipts, I'm going to have PG&E bills in my name, I'm going to have the key, I'm going to have mail coming to me. That would be examples of indicia of occupancy, and there's an inference drawn from that. It tends to establish who's in control of a home or a specific room. Other things that we might draw inferences from would be what we call consciousness of guilt or admission by conduct. And we use consciousness of guilt a lot in where we're trying to establish reasonable suspicion to detain somebody. In other words, I'm going to a burglary call and the person basically sees me and says, "Oh my gosh, it's a cop." You know, that would, and turns around quickly and tries to walk away, or they hide, things like that. Those would be examples. Additional examples of consciousness of guilt include flight from the scene or attempting to escape while awaiting trial, or flight from jurisdiction to avoid prosecution, or trying to bribe a witness from the case, or refusal to provide physical evidence. Another thing we might want to talk about at this point would be self-incrimination. We cannot draw an inference of guilt because someone wants to abide by the Fifth Amendment. They want to remain silent. So an adverse inference cannot be drawn from the initial refusal to answer police questions or the defendant's refusal to testify in court because of the privilege against self-incrimination. Neither can an adverse inference be made regarding a refusal to allow a search or assertion of any other constitutional right. Anything that's allowed in court has to be allowed by the judge. For the most part, someone would have to testify about given information, except if they give judicial notice. Judicial notice involves matters of common fact and general knowledge or law that are universally known, easily referenced, and not subject to dispute, and they're listed under 451 to 452 of the Evidence Code. Examples of things that could be claimed under judicial notice and matters of general knowledge include the fact that liquor is intoxicating, you get drunk if you drink it, that gasoline is flammable, that gunpowder is explosive, that arsenic is poisonous, that meth labs are highly explosive and flammable, and that a pellet gun is not a firearm defined by the Penal Code. And I want to go back to that meth labs are highly explosive and flammable. We were able to use judicial notice to show exigent circumstances in a situation that I was involved in as a narcotics officer. I had a call, and the person was reporting that they believed there was a drug lab, and it was in a highly populated neighborhood in southeast Berkeley. So I drove down there, and I could smell the chemicals. It has a very unique smell. It smells like tear gas to me, anyhow, a meth lab. And I was able to peek through a crack in the window, and I could see part of the chemical apparatus, you know, the configuration of apparatus that's used to cook the chemicals. So I called the fire department, And then I called our SWAT team, and we went in and kicked the door, and I didn't use a search warrant because I was worried that this thing could blow up. And so the whole argument in court was that, well, you should have got a search warrant, and the judge agreed with me that and found judicial notice that meth labs are highly explosive and flammable. This was in a crowded neighborhood, and it would be best that we tried to get entry quickly and be able to deal with the situation. So we were able to use judicial notice in that area. Judicial notice can also be used dealing with courses of nature, including the seasons of the year or sunrise, sunset, using tide tables. And it can also be justified using certain scientific facts and principles, including math formulas or forensic test methods and apparatus, including drug compounds or blood types or fingerprint analysis, police radar or DNA, and Kelly-Frye test. And Kelly-Frye, I think we talked about that earlier. That just means that whatever sort of testing you're doing, scientific testing, is accepted by the general scientific community. Other data that could be used is geographic data or historical facts, weights or measures, definitions of terms, including that crack is concentrated cocaine, or high crime areas identified by criminal statistics. Officers who attend post-certified training courses are presumed to have knowledge taught in that course without showing course outlines. We also have what's called stipulations. And stipulations is an agreement between the counsel, meaning the defense, and the prosecution, that a fact can be offered into evidence without adversarial argument. And this is done as a time-saving factor. Examples include the acceptance of testimony of experts who will give opinions, or a stipulation that a 10-year-old is competent to testify, or the counsel can stipulate that the defendant is a convicted felon in a 12021 case, which is possession of a deadly weapon by a felon. When it comes to polygraph tests, they're not admissible in criminal cases unless stipulated by both the prosecution and defense. And the counsel can stipulate to have less than 12 persons on a jury in a criminal trial if one person is found to be ill. The next topic is discovery, and that's the right of one side in an adversarial process to examine records, notes, witness statements, writings, physical evidence, lab reports, and any other evidence held by the other side in preparation for trial. Prop 115, discovery was made reciprocal, meaning that both the defense and prosecution get the information. This is hoped to save time and bring out the truth. The first case I could find that deals with discoveries in 1968, Smith versus Illinois, basically said that to deprive the defendant of the most basic information about witnesses, who they are, where they live, is to effectively emasculate the right of cross-examination. Historically, the general purpose of discovery was to help the defendant adequately prepare his or her case for trial and to assist in cross-examination of the people's case. The defense got to look at all the prosecutor's case before trial. However, the prosecution had to wait until the actual direct or cross-examination in court to know what evidence the defense was presenting. The Crime Victims Justice Reform, which was Prop 115, was passed in 1990, and it changed a lot of the rules for court. It basically made it reciprocal in that both the prosecution and defense were required to give each other lists of all the evidence and writings and physical evidence, lab reports, and witness statements that would be used in court. Discovery now exists for the following purposes. Number one, to promote the assertion of truth in trials by requiring timely pretrial discovery. Number two, to save court time by requiring that discovery be conducted informally between parties before judicial enforcement is requested. Number three, to save court time in trial and avoid the necessity for frequent interruptions and postponements. Number four, to protect victims and witnesses from danger, harassment, or other undue delay of proceedings. The rule is that mutual disclosure of information shall be made 30 days prior to trial unless good cause exists to the contrary. Good cause means threats or possible danger to witnesses, loss of evidence, or compromising an ongoing law enforcement investigation. This issue can be decided in an in-camera hearing by a magistrate. Now, an in-camera hearing is where the magistrate by themselves meets with the counsel that has the problem and determines whether or not they're going to allow the postponement of the discovery. This is done so that if you have a defense attorney and he's going to give the criminal information as to where the witnesses are or who the witnesses are, they can go out and kill the witnesses. So the judge makes a determination that that's not going to happen, and they basically postpone the discovery until the person testifies. The prosecution's duty to disclose extends to all evidence that reasonably appears favorable to the accused. And this comes from People v. Jackson in 1991. The prosecutor is presumed to know everything that the police know, regardless of the failure of the police to bring the evidence to the prosecutor's attention. This came out of a case in 1995. The defense also has a duty to disclose. The defense must turn over to the prosecution's names and locations of information of witnesses, any written or recorded statements of those persons, reports of statements made by experts made in conjunction with the case, and all other relevant evidence. What happens if they fail to comply? Deliberate failure to turn over discoverable materials could result in a contempt citation and levying of a civil or criminal sanction. Also, a judge could rule that no reference can be made to the evidence at trial. Example, in the O.J. Simpson murder case, the defense attorney neglected to send the results of the FBI carpet fiber analysis of Simpson's Ford Bronco to the defense. The fiber evidence linked Simpson to the crime scene. Though this evidence was relevant, the trial judge, Judge Ito, ruled no reference to the evidence could be made at trial. If trial proceedings have started and the prosecution failed to provide discoverable materials to the defense, the judge could declare a mistrial and dismiss the case on Sixth Amendment grounds. So it's really important that both sides pay attention to this. Failure to disclose certain information can also be grounds for a reversal of conviction. And here's some examples. Failure to disclose the existence of an eyewitness who corroborated the defendant's version of the events caused a reversal of conviction in People v. Jackson, 1991. Failure to disclose impeachment evidence on a material witness who had 3 prior expunged felony convictions and a pending spouse abuse charge in the Martinez case in 2002 overturned that conviction. Another discovery motion that is of import is the discovery of peace officer personnel records. This is called a Adjus motion, and it's the right to discover the names of persons who filed past citizen complaints against an officer about unnecessary use of force, illegal arrests, illegal searches, planning or falsification of evidence, falsification of police reports, untruthfulness, racial prejudice, or other dishonesty behavior. The statutory procedure is referred to as a Adjus motion again, and the defense is then able to subpoena these complainants to testify in order to support an argument of self-defense, civil rights violation, unequal application of the law, constitutional violation, or reputation for truthfulness. Law enforcement agency is required to have a formal policy for investigating citizen or internal affair complaints, and these have to be retained for 5 years. That's under 832.5 of the Penal Code. If the trial court grants a defendant's request, the officer's personnel file is ordered into court, and in an in-camera hearing, again, a judge is going to decide whether or not it's relevant to the case. If relevant information is found, the judge will order the release of identifying information, the outcome of the complaint. The defense is not entitled to record past 5 years unless a specific showing of exculpatory evidence is proven. The actual test of internal affairs investigation or pre-employment background medical or psychiatric examination results of the officer involved will prove one thing or another. Examples. A minor was charged with assault against peace officers. The victim's officers had 11 prior complaints alleging incidents of excessive force and racial prejudice. Basically, the court ruled the defendant was entitled to discover the outcome of the disciplinary procedures and any penalty imposed. In People v. Gill in 1998, the defendant alleged the arresting officers planted drugs, and they're entitled to discover prior complaints that officers have fabricated probable cause or planted evidence. In Brady v. Maryland in 1963, the defendant was entitled to discover results of internal affairs investigations where an officer was disciplined for lying to superior officers. And in Fletcher v. Superior Court in 2002, the defendant was entitled to not only look at complaints from the agency that the officer was currently employed, but within that 5-year period, the officer had been employed at another agency, and they were entitled to look at those records also. That is going to be the end of Lecture 2, Part 1. And what I'm going to do in Lecture 2, Part 2 is I'm going to go over some questions of review for you to hopefully help you in seeing whether or not you understand some of the terms and concepts that we just talked about. It's important that you go into the questions for review and true and false questions, and make sure that you work on your workbook in this area.